Welcome to today's LawWorks Legal Primer series on New Laws for Platform Workers. What do you need to know? This webinar is organized by Pro Bono SG in collaboration with NTUC. My name is Serene Gan, and I'll be your moderator for this evening. Before we begin, here are some housekeeping matters to take note of. Today, we'll be using Pigeonhole Live for our Q&A session. You can submit your questions at any time during the webinar and vote for questions by others that you would like to see answered. If you have a smartphone or tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. As you can see on the screen, you can then key in the event passcode LawWorks 2509. Alternatively, you can click on the link in the chat function to launch Pigeonhole Live on your device. If you're viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Finally, please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. And with that, I would like to welcome our distinguished speakers for today's webinar, Ms. Celeste Ang and Mr. Patrick Tay. Allow me to introduce to you Ms. Celeste Ang. Celeste is a principal in Baker McKenzie's Dispute Resolution and Employment Practice Group, with over 20 years of experience advising multinational clients on employment and employment-related issues. Celeste has been ranked Band 1 in employment in Singapore by Chambers Asia Pacific since 2019 and recognized as a litigation star in labor and employment by Benchmark Litigation Asia Pacific 2023. Next, joining us on the panel today is Mr. Patrick Tay. Patrick is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. He is also the Member of Parliament representing Pioneer SMC since 2020. Panelists, thank you for joining us today. Thank you, Serene.
Yes.
So for today's program, let me give you a quick rundown. Celeste will first provide a quick overview of the new laws on platform workers. The panelists will then discuss case scenarios before we wrap up with a Q&A session. I'd like to hand over the time to Celeste to share a brief overview on the new laws.
Thank you, Serene. Just to talk about the new Platform Workers Act. Just moving on to the next slide. Okay. So the Platform Workers Act, took effect on the 1st of January 2025 this year, and is to provide protection for platform workers covering work injury compensation, CPF contributions, and representation rights. And there was a need, for such legislation, considering that, in Singapore, there was a large number of platform workers, but they lacked legal recognition, obviously, as a labor class, apart from being self-employed. So in some sense, platform workers were self-employed and, they are subject to significant management control by the platform operators, but they seem to, in that latter category, resemble more like employees. However, unlike employees, they lack basic employment protections accorded to employees due to their classification as self-employed persons. The second, need, for legislation in this area was because, I think platform workers tend not to benefit from savings via CPF, which employees would be able to accrue from their work. And then this in turn obviously impacts on savings, for housing and retirement. And the third, consideration really is that in view of the nature of the work, obviously platform workers, especially ride-hailing drivers and delivery riders who would spend long amounts of time on the roads would be at higher risk of accidents. But they do not have the corresponding benefit, unlike workers or employees, of work injury compensation. And finally, the last consideration was that, since they weren't, legally recognized as employees, platform workers were also not allowed to form unions to protect their interests. So considering these four categories of needs, there was obviously consideration of a legislation to better protect, the platform workers. So come, the new laws. Next slide, please. So, following public consultation, as I mentioned, from 1st of January 2025, protections, for platform workers covering work injury compensation, CPF contributions, and representation rights were introduced via the Platform Workers Act 2024. And Singapore, is one of the first countries in the world and the first in Asia to recognize platform workers as a distinct and separate group of workers and to enact specific legislation to protect their rights. So now let's just turn to see, who the Act actually protects rather. So who does the Act protect, and who is a platform worker? So in summary, a platform worker entitled to protection under the Act must be one who is a ride-hail or delivery worker, has a platform work agreement with a platform operator, and is under the management control of the platform operator when providing the platform services in return for a payment or benefit in kind. So there are a few words here, right, just to explain. So the questions which arise from this is, what is a platform work agreement and what does management control actually mean? So the first one, a platform work agreement is essentially any agreement, and this can be written, oral, express, or implied. So any agreement between a platform operator and a platform worker for the provision of platform services to other persons for the platform operator. So generally, when we say if a worker is employed under a contract of service or an employment contract, then the worker would not fall within this definition, right? So it must be somebody who has a platform work agreement with platform operator. Now turning to management control. What does management control mean? So management control means that the platform operator can decide what tasks the platform worker performs, how they are assigned, how much they are paid, amongst other work conditions. So again, if the individual is not under management control of a platform operator in the sense that I just, described, then the individual is not a platform worker, but, a self-employed person. So what benefits, right, does the work, the Act actually provide? So this slide, shows the key benefits or protections for platform workers who are covered under the Platform Workers Act. And the key ones, which I would mention from, these 6 boxes here would be work injury compensation. So platform workers will be covered under the Work Injury Compensation Act. And this means that all platform operators are required to provide work injury compensation insurance to their platform workers. And, the platform workers will then, have the same scope and level of work injury compensation benefits as employees. So the second key one would be, in respect of CPF contributions. So platform operators, have started since the enactment of the Act, to contribute CPF, and they have also deducted CPF contributions from the platform workers' earnings and submitted them to the CPF board every month on behalf of the platform workers. And then the final one, which I will just, mention, is representations. So platform workers can organize and represent the interests of fellow platform workers by registering with the platform work associations to negotiate, with the platform operators. Next slide, please. So I think looking forward, as with, most things, there are obviously areas for improvement or, developmental areas as we call it. So the first is that obviously the Act, as I mentioned, covers only certain categories of platform workers. At the moment, its application is only to delivery and ride-hailing services, and it excludes all other types of, platform work, for example, cleaning services, caregiving services. The second, area, for development, is that, because some of the algorithms which are run by the app, can create certain biases, right? So there are certain, certainly obviously risks, of discrimination in respect of the algorithm used on the apps. And, there's also concern that if platform workers who fall within the Act, are entitled to CPF contributions, that may, be a category of discrimination. And then the last one, the third one is wage insecurity remains a concern. The Act, does not, for example, provide a minimum wage equivalent. Next slide, please. And then the final 2 points, would be, obviously there's lack of protection against workplace harassment, for platform workers. Although, the Protection from Harassment Act obviously applies, to everybody. And then the final one is vulnerability to app destructions. So I think, with that overview, I'll hand back to Serene. We can maybe run through some scenarios to bring to life the law.
Thank you, Celeste. So let's go through some case scenarios because there's nothing like seeing how the law might apply to realistic scenarios. So let's go to our first scenario. Peter is working full-time job in a company. He is thinking of becoming a platform delivery driver as he heard that he can earn more money per hour and there's more work flexibility. He's not sure whether to try out as a side gig first or go into it full-time. Patrick, so what are the general differences between being an employee versus a platform worker?
Yeah, very important. I think Les earlier alluded to it about this dichotomy or difference between someone who is in an employment relationship and not in an employment relationship. Yeah, nowadays there are many different nomenclatures or even terms being used. For example, we call them gig workers, we call them informal workers, we call them contingent workers, we call them sometimes loosely termed contract workers, or even from a legal perspective, we call them independent contractors or otherwise known as contract for service arrangements. So that's the difference in law, i.e. whether it's contract for service or contract of service, which connotes employment relationship. Why is this important? Because if you are in an employment relationship, there's a lot of statutory laws that come in place and come in play. You have the Employment Act and a whole compendium of labor laws in Singapore that protects those who are employees and in an employment relationship. So that's very, very important. And it also covers, I'm from NTUC, I must say this,
Yes.
trade union membership as well. So membership of trade unions are only open to those in an employment relationship.
I didn't know that.
That's prescribed in the Trade Unions Act.
Okay.
Yeah, but I have to really make this point about this difference between a person in an employment relationship and not. Where, example, today we're talking about platform workers. Many of them, for example, in ride hailing or even in delivery, may not. They may think that they are in an employment relationship or they're doing a side gig. However, unfortunately, good to read the fine print.
Yep.
Because what is sometimes it's not even in the fine print. It's probably in a website or an app where you agree and tick the check boxes and say agree and okay, and consent. So also they have to be careful. However, later we'll talk a bit more. We have now the new Platform Workers Act, which has sort of tilt the balance and level the playing field a bit. I think this came about because there were a lot of discussions and consultation on the ground in the last 5 to 8 years. It's not a short journey actually. We talk long and hard, tripartite partners, Ministry of Manpower, some of the operators, as well as the NTUC and the labour movement. We should talk long and hard on how can we better look after this segment, because increasingly, even as we are talking, if you look at freelance workers, that's another term they use, freelance workers, or in Ministry of Manpower's terminology, own account workers, they contribute about 10% of our workforce in Singapore. So and mind you, yes, 10%, large, a big group, but if you really look at those more vulnerable ones, because in the course of many conversations, we embarked on the Every Worker Matters conversation a couple of years back, and we spoke to many of these ride-hailing workers as well as delivery champions, we call them. We realized there's a need to better look after their needs and their rights and privileges. Because they are sort of in an employment relationship, but actually there's no employment relationship. So how do we circumvent or overcome that? So that's why the Platform Workers Act, I would say, is a great boon for platform workers. It's a good start. I know in some other jurisdictions you're looking at all kinds of gig workers, but in Singapore we are starting with platform workers first because a majority of them could be doing it as a side hustle, freelance, over weekends, and generally more vulnerable. Why? Because they are at the mercy of the platforms. How they later we can talk a bit more how they build in the algorithms and I remember very vividly. A couple of years back, one of the those delivery champions were doing a delivery for food delivery. It was crossing the so-called zebra crossing near Jurong Point, the area where I look after, and he accidentally scratched a very nice luxury car, and because of the handlebar, it kind of caused a very deep scratch, and it was a brand new car, and then the insurance made a claim against him, and he had to fork out $5,000. Imagine his per delivery is probably earning a couple of dollars, and how many thousand deliveries he needs to do to actually make up for that payment. So it was a very, very precarious, very vulnerable situation. And that's only if you cause property damage. And what if you are knocked down and you pass on, or you sustain major injuries? So most of the time, as we all know, if you are an independent contractor or not in an employment relationship, there's no laws that protect you. So lo and behold, now with the Platform Workers Act, we have what I call the three-piece meal. I like to call it three-piece meal because, firstly, you'll be covered under the Work Injury Compensation Act, under the auspices of the Act now, with effect from this year. And therefore, if they are injured in the course of work, later we'll talk a bit more, they can cover. The second piecemeal is now we have union representation. So we have platform work associations, and of course the platform operators will have who are part of this association sort of acts like a unionized company, and now we are given rights or powers to represent these workers when they are aggrieved and they face issues, whether they're terminated unlawfully or they face issues in the workplace and grievances. So that's the second piecemeal. And third piecemeal, very important, is also Central Provident Fund contributions. So we are worried about the retirement adequacy, just like all freelance workers, because, well, there's a basic rudimentary requirement to contribute as a freelancer to your MediSave and some of the CPF obligations. But with this, we want to better protect them because they may belong to the more lower wage segments, and therefore there's a need to better look after their needs, especially if they're gonna own their own their flat, their home, or maybe for their own healthcare premiums, etc. So I thought this will be the third piece of the icing of the cake, which we are presenting to platform workers, particularly those who are union members in and with the new Platform Workers Act.
Thanks. I'm glad to hear that there's the change in law to try and address these gaps. And at the end of this session, don't worry, we do later have a slide with more information about NTUC and how you can join as well. Maybe
just add on
yes.
a point. I think the Platform Workers Act does not negate the application of what we call, common law. Right? So
That's right.
Under common law, there's always the vexed question of whether you are in fact an independent contractor, as you may call it, or that parties are in a de facto employment relationship where, even though you may be seen, or at least contractually, you're trying to, you are an independent contractor, but the laws may give you some protection if, in fact, you are an employee, right? So I think the Act, just to make it clear to to our audience, is that it doesn't override the common law application of your independent contractor versus a de facto employee. Just to supplement that point.
Thanks, Celeste. I think picking up on maybe one of the concerns brought up by Peter, because he's thinking, should I have this as a side hustle or should I do it full time? Is there a difference? From a legal perspective.
Yeah, so in respect of, I think, any individual or employee who has a full-time job, considering doing it as a side hustle or doing it full-time, I would say the first place that you want to look at is your employment contract. So, whether an employee, so if you're already in a contract of service with an employer, whether you are allowed or permitted to take up additional role as a platform worker, whether on a part-time basis or maybe on a semi-full-time basis, will ultimately depend on your contract and your terms of contract with your employers. So some employment contracts, will prohibit secondary employment or moonlighting or part-time, as case may be, or at least require prior approval from employers as well. So be mindful of express terms in your contract. And certain contracts, or at what we call common law, right, there may be also implied duties of fidelity, right? So certain provisions, express or implied, may also impose confidentiality or conflicts of interest kind of obligation that restricts employees from taking up or working as a platform worker.
That's right.
So you do need to consider what your employment obligations and terms are. I think the other thing to note is that even if an employee, or if you have an existing employee and you wish to be considered, or you wish to take up, a part-time job as a platform worker, all your obligations as an employee would still be maintained, right? It doesn't mean that because you're part-time now, you maybe have lesser obligations as an employee. No, you still have your employee obligations. And then obviously your CPF contributions, would still be the same, for your employment and, for your job or part-time job as a platform worker. And then the last point, is that both sets of income would have got to be reported for income tax purposes.
Oh,
Yes.
Yes.
Yeah, that's important. Definitely.
You don't need to report it as
Yes. Still,
Yeah.
trade income.
Okay, I mean that's true. Something interesting to note about if you have it as a side hustle, you do have to remember to report it come tax season. We do have a question from an audience member. Are platform workers required to have a written contract? Or I guess maybe the confusion is, typically if you were to have a full-time employment job, you typically would have what people look at it as a very nice or maybe hard copy document to sign. Platform workers, I think it's online. So I think there's a little bit of question around, do you kind of need like a physical hard copy? Yeah.
So I as a lawyer, I would say that for certainty, it's always good to have something in writing. But as I mentioned earlier on, right? I mean, in terms of the act itself, the concept of platform work agreement, really just to protect the platform workers, is an agreement that can be oral or written. So it's not expressed that it has got to be written, unlike an employment contract. And that's really to give protection to the platform workers who may embark on something, and if the employer says or the operator says, just because you don't have a written contract means you do not get protection under the Act. So the Act does not require it to be written in order for you to have protection under it.
Okay, that's
But
good.
as I said, it's been a best practice of
Yeah.
to have it.
I mean, being a platform, naturally, everything will be digitalized,
Yeah.
digitized. So, always good to, after you sign or mark the lozenges and submit, do a print screen, just in case.
Yes, I mean I think that's quite important. For the audience member who's asking about this, that even if it's online, it appears that it's binding. And do print screen or save a copy of it. All right, so let's go to our next scenario. So we're following Peter on his journey as he becomes a platform worker. So Peter, he decided to quit his job to be a delivery driver for Koala Platform and a ride-hail worker for Orange Platform. Okay, so he decided to go to be a platform worker for two platforms. Peter intended to drop off the passenger from Orange Platform at a mall, then carry out some food delivery services for Koala Platform. Unfortunately, whilst driving to the mall with the passenger, he got into a car accident with a cyclist who ran into a red light. Who ran the red lights. So Patrick, I think you earlier mentioned about the 3-piece meal, and I think you alluded to, workman injury compensation. So in this instance, is Peter able to avail himself of any compensation?
Yeah, if you look at it, now, I mean, the platform workers, unlike before the Act was passed, will now have protection under the Work Injury Compensation Act, very much like any other employee or anyone in an employment relationship. So that's one big step forward, I think, and particularly so for platform workers who may not actually have the means sometimes, or even have the resource to protect themselves in the event of injuries or sustained during the course of work. So I thought a few operative things are very much similar to an employment relationship. When an employee files a claim under WICA, that's the short form for Work Injury Compensation Act. So the WICA claim, I think there are a few important things that actually WICA covers. It covers medical expenses, it covers compensation for income loss, as well as lump sum compensation for permanent incapacity and even death. So these are the few hits of claim under WICA. But more importantly, the operative word is in the course of work. So we all know that this has always been a question mark, whether the injury sustained in the course of work. So In the platform work or platform worker space, there are two particular groups here we are protecting. The private hire vehicle drivers. That's why we have the National Private Hire Vehicle Association as well as the National Taxi Associations, because taxis these days do both platform as well. And the other one, the very, very big group are the delivery champions. That's why we created the association called the National Delivery Champions Association, NDCA for short. Why do I need to mention the MPHVA, NTA, and NDCA? Why? Because they are going to be the unions that are going to be representing you if you are a platform worker. And so do be a member with them. Just like any other NTUC member, you can be a member with them and then have an additional layer of protection and representation, which is now availed. But back to the point on work injury compensation, it must be in the course of work. So there are two situations I can think of. Firstly, when you at the time of sending someone in a private hire vehicle situation from point A to point B, so that's the whole trip process. And for the person doing the delivery of the food or the parcel, it will be the point where they start to the point they deliver. So I think this is the cost of work that we are envisaging under the VCAR cost of work for platform workers. So need to be aware that it has to be during that either that whole journey with the customer or the whole delivery for the particular puzzle or food item. Why do I say this? Because there are some situations that are not covered. For example, you're a platform worker, i.e. a private hire vehicle person, a driver, and you happen to be waiting at a car park nearby a very crowded area or waiting for the next customer to get injured. Unfortunately, that's not in the course of work because you haven't picked up a job. You're just waiting for a job. So unfortunately, that is one of the situations that are not covered. Likewise, if you are delivering food or you're delivering puzzles and you happen to, in the course of it, run some personal errands, unfortunately, that is also not covered because it's not in the course of work. So, we'll wait for some of the cases to develop and some of these cases to come up. But otherwise, fundamentally, it's very much similar to like in an employment relationship, what is doing in the course of work. So I think that's some important pointers for our audience here, particularly if you're a platform worker and whether in a private hire vehicles situation or in a delivery situation.
Thanks, Patrick. I think this scenario resonates with some of the audience members. I suppose, since they are gig workers or platform workers, they might as well sign up for a few platforms at the same time. So I think following on that, because in this scenario, Peter arguably is doing things for two different platforms. So when that happens, does that mean he can claim against both or one? Or I'm not sure whether there's any thoughts around that, Celeste.
Yeah. So in this case, so looking at this scenario, Peter was working, for two platform operators when he was injured. But in this scenario, he was performing in terms of what he was performing when he got injured, it was the pickup task. That's where he got injured, right? So analyzing this scenario in terms of the process, it would be that, post-accident, the process would be for Peter to inform Orange Platform, because his platform operator for the task that he was conducting at the relevant time of the injury is actually Orange Platform. So he would inform the platform operator for the task he was conducting at the time of the relevant injury, and that's Orange Platform, of the incident and the injury details. Then in turn, Orange Platform will then file a work injury report to MOM as well as its insurers. And it will be notified through the process under WICA, right? So, especially say that's a short form for the the Work Injury Compensation Act. And then, thereafter, Peter will be notified of the WICA claim case reference number and the insurer processing, the claim as well. And in this process, the insurer may reach out to Peter for more details about the claim. So, in terms of the analysis for a WICA claim, I think what is important is in determining who to make the claim against is basically, how many platform workers are you working for at the relevant time? And at the time of the injury, what task were you actually doing, right? I mean, if it's only attributable to, say, in this case, the task for the ride-hailing service, then that would be the right, employer to make the claim against. But of course, there are rules around what happens if you're doing, claims for both operators, then, what the process of the claim is. So there are different permutations depending on what you were performing and how many operators you were performing the work for. So that would be the process for the claim. So in this case, in the event of a successful claim, Peter would be entitled to income loss compensation, during medical or hospitalization leave. There is, the compensation. So because in this scenario, he would be only claiming as against, the picked up task, right? So the compensation in this case will be based on Peter's total earnings from the ride-hail task over the past 90 calendar days. But if it was a different scenario, then obviously the method of computation will be different. But because this is only one, of the limbs, then his compensation, will be based on total earnings from the ride-hail task over the past 90 calendar days. And then the next limb is medical expenses. Generally is $45,000 or medical expenses incurred 1 year from the date of accident, whichever is reached first. And then in the unfortunate event, of more serious injury, then the lump sum compensation for permanent incapacity or death, as the case may be.
Thanks. An audience member, I think, picked up that he ran into a cyclist who I think will quite obviously be injured. So the question is, does WICA apply to third-party claims? So, for example, the cyclist is injured. Does that apply to WICA? Or how does a cyclist make a claim?
So WICA covers the work injury of the rider or the platform worker. It doesn't cover the party claim. The party claims will be covered under your usual motor injury. Your motor insurance.
Yeah. So in most cases, for example, like the national or taxis or ride hailing or even in cars, I mean, before you can even start getting it on the road,
Yes.
you need your insurance, and that's kind of nicely linked with road tax and everything else. So therefore, insurance for third party would have already been provided. But I really urge our viewers, especially those who are doing platform work, i.e. ride hailing services, to really read the fine print. Because most of them actually don't own their vehicles themselves. They could be leasing it from someone, probably a vehicle leasing company, and therefore good to read the fine print. They may give you a good package and say, this vehicle is leased and you just pay me this lump sum, your insurance all covered. Oh, so insurance all covered. So what is all covered?
Yes.
So it's always, I strongly advise, because we do have situations or scenarios. In fact, personally, I've seen the residents who have come to me and who are doing ride-hailing services and have leasing agreements, realize that some things are not covered in the insurance. It's a very basic package, or sometimes very rudimentary. So just really the very basic stuff, and the very low values and even very high excess. And therefore, they need to read the fine print to make sure that they are well insured. In case, touch wood, in case like in such a case where there's injuries caused in the course of carrying out the work or the ride-hailing work or very work.
Yeah, I think, that's a very good, reminder, right? So, other than ensuring that you've got insurance and that people who you may lease vehicles from, are in fact giving you some form of a coverage. It is, I think it's a good reminder that generally injuries which will not be covered by WICA or which are excluded, right, in respect of platform workers, which may be relevant, will be if the platform worker is performing a task, although it may be in scope, but if it's a task using an illegally modified vehicle, which caused the accident, then it's out. Or if you're performing a task while using a vehicle for which you don't hold the appropriate vehicle license, that is also not. So even though you may be within scope, but because it is a vehicle for which you don't hold an appropriate vehicle license, then you won't be covered by WICA. And then the third one is, if you are performing a task using an unregistered PMD, that will also be excluded.
Because remember, when it comes to deliveries, it's not just cars, but also motorcycles and, of course, personal mobility devices that are registered and LTA certified as well.
Yeah. That's right. Okay, so I think an important reminder to all those potential platform workers or current platform workers, do check your insurance coverage because that could be very helpful. So I think a clarification question that we received was that, so in other words, what you're saying is that if a person is injured by a platform worker, in this case a cyclist, they can still pursue a civil suit or action against a platform worker for the injury. So the Act doesn't change that.
Yes, that's only for weak car claims, it's injury to yourselves lah, because of work.
Oh.
So take note, insurance. I know some of the platform operators have started providing some form of very basic coverage, but it varies from operator. So it's good if it's not already provided. So again, when you sign your so-called when you get into this contract for service or this when you work for a platform, read the fine print, see what's covered, and to make sure that you insurance, it's not just for personal injury, but the cost of work, but also if you cause damage or property damage or injury to others, that may well set you back quite a bit of money. So, for example, I've got one case. The person doing delivery was in a motorbike. I was delivering to a particular landed property, and he sort of like left his bike near the gate, and then when he took out the food to deliver, the bike kind of like the brakes went off, and then he went into the gate, and the whole gate collapsed, and it caused a big dent and damage, and that came up to like a 5-figure sum of money. So these are things which I hope as you embark on some of this work, sometimes the scary part is some of them are doing this as a side hustle or as a gig on a weekend or some free time. Still need to read a fine print. You never know. It's good to always protect yourselves. That's our message there. So the laws, the new Platform Workers Act can cover you for 3 areas, but beyond that, do watch out for more of the other kind of damages we just shared.
Thanks, Patrick. Let's go on to the next scenario. So unfortunately, Peter was terminated by Koala Platform due to a customer complaining that he has eaten part of their food, which he did not, and another customer complaining that he was rude to her. So Patrick, because you mentioned about how there's now a Platform Workers Association, so how can the association assist Peter?
Yeah, there are 3 main associations I shared earlier: the National Taxi Association, National Private Hire Vehicle Association, as well as the National Delivery Champions Association. So I would think these are the more relevant ones to every one of you who are platform workers. So if you sign up as a member, although they are called associations and they're incorporated associations, but I shall use a more generic term, union, since they are part of our affiliated the National Trades Union Congress. So they are our union sisters and brothers in that sense. And therefore, if you are a union member and part of these associations as members, what I shared earlier, the 3 Ps mean, one of the key things is representation. Union representation in very much like in an employment relationship. So we are very thankful that we are given this new local standard to be able to represent this kind of workers, this segment of workers, because traditionally it's quite binary. Either you're in an employment relationship or you're a freelancer, you can only represent the private. But now it's sort of like a hybrid. We can't represent them for everything, but at least in terms of union representation, for example, in this particular scenario where they, because of what in the view of the company is that you have failed in your duty and therefore I'm terminating you and terminating your services, or impose some form of penalty on you. And maybe instead of giving you, you lose it. Some of them have incentives. So they may lose all their incentives and stuff like that, and really affect their income and their takings quite a bit. Then that's where the union can come in. How does it come in? There are a few ways. Firstly, we can, in such a case, if they are unfairly terminated because of, maybe a misunderstanding or sort of a miscomm, or it could be a quarrel with a customer as well. A similar situation like that is your word against mine kind of thing. Then, if it's union can make representation to the Ministry of Manpower, particularly to the minister, to make representations on this. That's one example. In the other sense, we also give them support. if they face injuries, social welfare benefits, which NTUC and Labour Movement has been hard at work building, and raising funds to support our platform workers in event there's an income loss because they get injured at work, or some extenuating circumstances that befall them. Sometimes it's not injury, it could be a prolonged illness, for example. So we do have actually help schemes to support them. So representation, help schemes, and actually the interesting thing is, I think this is quite landmark in Watershed. We can now actually enter into a collective bargaining with the platform work, or should I say platform companies and platform employers, platform work employers. Why? Because in a way they are in the weaker side of the bargaining, and therefore with this representation, not just at the individual level but collectively, now we can actually represent them and enter into collective bargaining arrangements with the company, or otherwise known as the platform operator, to better look after the rights and privileges as platform workers. So therefore, that's why this call out to all of you, be part of the union membership with these associations. If you are doing this, not just even as a full-time job, some are doing it really as a full-time job and doing it on a very regular basis. But there are those who do it as a side hustle, a gig over a weekend, some pocket money, or some students do it like a pocket money. I think it's also good to take this membership up so that we can look after you in case any eventuality happens. So this is an added sort of like a safeguard and support for platform workers.
Thanks, Patrick. Maybe to Celeste, I think it's great that, if you're a member of the association, they can step in to help you in certain circumstances. But Celeste, maybe touching on, besides approaching the association, what could Peter do in such a situation?
Yeah, so, I think some self-help, might be good. So in terms of, what else, Peter can do before, he makes a claim if he wishes to, for a wrongful dismissal or wrongful termination claim, as the case may be. It might be good to collect, some evidence of his own. I mean, now with technology and all that, it's not difficult to, collect some evidence. And I think what I'm going to go through, is something which may give certain tips, right, to our audience as to what they may want to be mindful of in terms of, how they go about doing their jobs as well. So, as an example, delivery photos or videos. So, if Peter had taken any photos of the food before or after delivery, what the condition of the food is, these could help to prove that he didn't eat it or tamper with it, as the case may be. The other one is, I think with technology nowadays, GPS and time logs, that sometimes can help. So delivery app logs, showing, for example, the time spent at the restaurant, and the customer's location could potentially help to show that he actually didn't have time to eat half the food or, all of the food, as the case may be. So that, could potentially help. So things from the app itself. And again, if anybody, from the restaurant, the restaurant staff or other delivery partners may have seen him on the road, and we do see quite a lot of interaction on the road sometimes. They can see that, either the food being packed, being delivered, what the condition was. And, Peter handling it, for example, their testimony could also help in terms of getting the evidence that he may need. And then for the rudeness complaint, if the communication is through the app, then obviously if you have a trace of what the communication is, that could potentially help as well. If they have, access to chat logs, documenting the communications, that, would also assist, his case as well. Again, if there's recordings, and some people, they do actually record certain events or incidents, or when they are approaching certain people and there's certain concerns, maybe some recordings might help in that as well. The last one is obviously customer rating, right? So if, Peter has been in the business for a long time, and he's always received good ratings, then these incidents could be seen to be more unlikely than not, right? So again, customer history ratings could prove to be helpful. So history of good reviews, good ratings could help to counter the allegations of rudeness or, that he's taken, part of the food, for example. So things that you want to think about. And again, like I said, these illustrations can maybe give, our audience some ideas as to how they may want to protect themselves in the event of, these incidents. Because it's a lot of these are going to be, he said, she said kind of issues.
So like what Celeste mentioned, I think, of course, if there's a member of Platform Work Association, with the association and the union can help you. However, if we are not, you can still do a lot of self-help. And in particular, if you notice what Celeste mentioned, all the practical handles is basically to gather evidence to support your case. Because if it goes to a dispute, or even sometimes not a dispute in court, but sometimes a dispute with, for example, the insurance or company or the insurers, and then they are disputing over the amount. So whatever evidence you can gather, I've seen some who, of course, some have vehicles. They actually install cameras inside and record it and recordings, and they save them. Some who are on mobility devices actually put nice cameras on their helmets, and even on motorcycles they put a helmet or in front of the near the handle, so that they can record everything, so that in the event of any injury caused or property damage or accusations, or sometimes even conversations or arguments that may arise that may compromise your work. These are good evidence and worthy ones that can, in a way, provide more clarity. If in the event we need to resolve the dispute, or we need to mediate over a matter which the other side makes a claim.
Thanks, Patrick. I think there's nothing like and also Celeste as well, for having such good practical tips, because it's always good to try to resolve it before it escalates further, or before you're even terminated. So let's move on to our Q&A session. As a gentle reminder to our participants, you can still submit questions via Pigeonhole.
Yes. And Serene and Celeste, I got good news for audience today.
Okay.
Yeah. Actually, before we go into the Q&A, I know you all have lots of questions, but the good news is, as part of this LawWorks partnership between the National Trades Union Congress and Pro Bono SG, we have, for the benefit of all our platform workers, have done up the latest pocket guide. Because as part of this LawWorks partnership, we actually do what we call a 3-piece meal as well. Firstly, tonight's primer is but one of the initiatives. We've been doing this for a decade, and doing for various segments, different topics. So the second one is a monthly legal clinic. So all of you, including platform workers, you can have, if you are members, you have access to our free monthly legal clinics. And the third is this pocket series. We've done a whole series of pocket series that you can use as a quick reference guide. Layman terms, minus all the legalese. And frankly, I was just reading it front to back. I think easily will not set you back more than 15-20 minutes. Why do I say this is important? And we're going to avail this to everyone. This is my only hard copy. Yeah, and it will be available for downloads via my socials. I'll try to, and including Pro Bono SG socials, and we'll give you the link as well. I'll post the link on my socials, whether LinkedIn, Facebook, Instagram, whether by tonight or tomorrow. And we'll give you access to this, and feel free to download it. It's in a PDF copy, and share far and wide. I know many of you platform workers actually have very close Telegram and WhatsApp groups. So do me a favor. Yeah, get the link, share widely with all your friends, and really, I think many thanks to the contributors to this and my NTUC team for editing and going through this as part of this LawWorks partnership. 7th pocket series. There are a few others. For example, if you are in other trades or even employment relationship, you get workplace bullying, harassment, and stuff like that. We have a whole very, very topical, hot topic pocket series. And this one is particularly useful because what we've just shared in the last more than 45 minutes are all encapsulated in this in the very readable manner. There's even a checklist at the last 2 pages to tell you, if you're a platform worker, what you need to do and where to get help. And including some of the web links I alluded to earlier on CPF contributions. So the web links inside there in the CPF website, where you can find out how, or depending on which year you're born in, and really how you can save as a platform worker. So it's provided there, the link. And also situations where the WICA covers and does not cover. So in there. And also and also the MOM website links in the event you get you sustain a work injury as a platform worker. So it's all there, and I thought it's a great resource for all our platform workers. Really fresh from the oven. Just completed this not too long ago because the act just passed, but we were in the course of forming platform work associations and working closely with platform operators, and therefore please grab hold of a copy of this. You can't get a hard copy, like we try not to kill trees, so we are sharing it by PDF and by web link. So use that and help me and our team to share it widely so that more can better look after their rights and interests.
No, thank you, Patrick. I think it's so useful to have a guide because this is such a new area of law that I haven't quite seen before, a platform workers act. So it's really handy to have this guide. In fact, an audience member asked, is this accessible to the public or only platform workers? I understand that the link has been put in the chat. No, you don't need to be a hired platform worker in order to read the guide. It's free for download for everyone.
Maybe it will help you make a better decision whether you're going to go into platform work.
Okay, yes. Okay, so you can read out, understand.
You never know. I mean, compared to prior to the act and now, definitely more protections, definitely much more interest and welfare looked after, and really must thank the partners that has been in this journey coming out of the act, and of course with this guide quite contemporaneously after the passing of the act.
All right. Thank you, Patrick. And thank you everyone for your questions. Please feel free to let them come in. When I look at it, it's really quite interesting. I'll classify it to two categories. First is clarification, around this new act. And second is very philosophical question about the future and thinking around the act. So maybe I'll first go into the clarification part. So our first question is about, I think, health and safety. So they are curious that for this act, is there anything about protecting or ensuring that platform workers are not overworked? Is there like a limit in terms of how long the hours they can work, etc.?
Yeah, maybe if I may add, I actually, thanks for the question. The answers are actually in this pocket.
Okay.
Yeah, it's on page 14. I'm going to attract all of you to download it.
Okay, if you download it, you can go to that
14
page.
60, but essentially it says that the Workplace Safety and Health Act of 2006 was amended. So the good news is to include the duties of platform operators to ensure the safety and health of platform workers as well. So I'm literally reading off the headline of this because yes, the answer is the WSH obligations will kick in, and therefore just to give all our platform workers there or those who want to go into this endeavor a peace of mind that the WSH Act does cover platform operators.
All right, that's fantastic. Can a person be employed in multiple platforms, or is there a limit?
You can. So the short answer is you can be, employed by multiple
Yes,
platforms.
definitely. That's why some of you who take some of the ride-hailing services or private hire vehicles, you do see sometimes they have two handphones there.
Three?
Yeah, or three. Yeah, we know you have Gojek, Dada, and Grab. So sometimes you see, the screen platform is a bit different. So yes, I do see because many of them are really working and trying to sustain and make a living. Really, sometimes many of them hand to mouth, and therefore working for one operator alone may not be able to sustain. Because like I said, the takings are quite variable and quite varied. And that brings in the point on the better need to look after their interest. Because what we are particularly worried, the labor movement, is the algorithms. We hear a lot of stories from the ground and mentioning about how the algo does affect them, whether they get 5 stars, 4 stars, or get in various kind of levels of incentives, which may differ depending on the number of trips they do, number of stars they get, and number of trips they manage to cover within a short period of time. All these actually affects their incentive payments of sorts, and therefore in times when maybe, for example, where maybe during the school holidays, for example, many people are away in December and there's not much passenger traffic. So sometimes they do actually they do work for two different operators just to make sure that they can make the ends meet.
Yeah, I think the risk of discrimination, with the algorithms, it is quite real, isn't it? Because the algorithms, are crucial to the platform services, and the efficiency is to maximize profits. And because of that, the unintended effect is that, and that's unregulated, it's often that, it may have create some discrimination risk, right? So, for example, if workers have unpredictable caregiving responsibilities, and they suddenly need to cancel work assignments because of the responsibilities, this may then, impact on
Prejudice and
on their ratings. Or if, delivery workers, they choose to decline jobs because they have real fear for their safety going to certain areas, again, they may lose out on job opportunities, right? So, yeah.
Thanks, Celeste. Thanks, Patrick. Good to know. So another question is the concept of, I think for employees, they have paid maternity leave and perhaps paid paternity leave. Does such a concept apply to platform workers? Paid maternity leave and
Okay,
paid paternity leave.
Yes. So there's actually provisions for maternity leave, etc., even for freelance workers. But there's some conditions to fulfill. And therefore, if I give a short answer, is yes, because some of them are government paid, and you must be involved in some form of work. So if you are, it's not just platform workers. Even if you're self-employed, and you fulfill some criteria and have some, well, in a way, proof of a sort of income. Therefore, you can make your claims via the provisions of for maternity. So yes, the answer is, however, there's in a way no maternity leave in a sense, because you're a freelance operator. So technically you don't take leave, but when it comes to other privileges and benefits, there are some form of calculations to make sure that you can tide over that period.
Yeah. So I mean, it's not leave per se, but
Yeah.
you're probably referring to like the CDCSA kind
Yes.
of not reimbursement, but certain benefits that you can claim based on whatever income that you have, that's subsidized by the government. Yep.
Is there a requirement for platform workers to have insurance? Especially those who are delivering via, let's say, PMD or bicycles.
There's no legal requirement unless you are, but most of them that do buy insurance are usually either driving or motorcyclists. So therefore, by virtue of the fact that they are, there's road tax, there's LTA requirements, therefore they buy it. But for cyclists, for example, they may not. There's no mandatory requirement. Therefore, my call out to all you out there to purchase these are important.
Thanks. Maybe I'll just, maybe since I have Patrick here, I'll just ask some philosophical questions. I mean, feel free to let us know if it's something you thought before, or maybe you may not know the answer to. I think, so one audience member was saying, well, there's platform workers. So besides, of course, the ride hail and delivery, there's also perhaps designers and other sort of services. So why focus on delivery and ride hailing first? Or is there thinking just to start with them first and perhaps expand it in the future? Or why them over others?
Yeah. Thanks for the question. Definitely, there's the reason why we went for platform workers first, because I think this, like I said, we've done quite a lot of conversations on the ground for the last 5 to 8 years, and many of these grievances, issues emanate from this segment. And many of times they are a bit beyond their control, and particularly they are working for platforms at the mercy of algo and whatever the platform says. So therefore, we identify, and most of them who are platform workers, whether they're ride-hailing or delivery, tend to be the more lower wage earners. And therefore, we have started this journey to look at these two vulnerable groups first. So it's not a closed door. Yeah, I know in other jurisdictions, they have now expanded beyond just ride-hailing and delivery. Looked at other more freelance arrangements, for example, in the creative sector, in photography, including other spaces. So I wouldn't say it's a closed door, but this is definitely our very first attempt at looking after the most vulnerable in the freelance or gig arrangement. So that's the answer to, if we're wondering whether is this the end or no more. But I must say we have been quite daring because we are one of the first jurisdictions in the world. Probably in some parts they are only states, but we are very first national piece of legislation to look after platform workers in general. In fact, because of my interactions with many labor movements across the globe, they are very, very interested, and they're wanting to pick a leaf from what we're doing here in Singapore. And I know some jurisdictions have started picking a leaf and starting their own pieces of legislation, including at the International Labour Organization, looking at how we can better. In fact, we showcased this a couple of months back at the International Labour Conference in Geneva, where we shared how our Singapore experience in better looking after platform workers, because there are currently, actually, you look at in Europe and other parts of the world, there are other arrangements. For example, like framework agreements and industry agreements to address specific needs of freelance platform workers. So, but we have taken a bold step towards legislation. I think it's only we are into its 9th month only.
Yes.
So we'll see how it progresses and whether there's a pressing need to better look after other own account workers or freelancers. Like I said, we have about 10%, depending on what denominator you use. We have about 180 to 200,000 freelance workers or own account workers in Singapore. This segment is quite big. It's a 5-digit number of workers, and well, it's a moving goalpost because some come by, take it up, some drop off. So it's I can't commit to actual numbers as per today, but there's quite a critical mass of them, and therefore we're starting with this first. I would say the first, the 10 to 20% first, and then the others. If you look at the other sectors, for example, like in the creative industries, or maybe they are own account workers or self-employed people, they're running businesses, for example, providing professional services, then a bit different because they are possibly in the more median, more above the 50th percentile kind of workers, and therefore may not have as a pressing need as such low-wage workers, which are very vulnerable. So that's why we are starting on this, and the rationale and the genesis behind. Because you'll be wondering why platform work first. Well, I'm also a freelancer. But we have in the labor movement. The good news is gone into different spaces. So we identified, of course, the National Taxi Association. We started a long time ago, decades ago, about the National Private Hire Vehicle Association is one, go after ride-hailing workers, and of course the National Delivery Champions Association. But however, in fact, in the last 8 years, we have started various associations. For example, VICPA. VICPA looks into the visual arts and creative sector, including the photographers as well. So they are actively now doing a lot of things, because we realize, for example, in the creative sector, in photography, very particular about, concerned about intellectual property rights. So that's where we partner with IPOS, Intellectual Property Office of Singapore, as well as other organizations, including with Pro Bono SG as well. We actually did a couple of primers on this. In fact, a few of our pocket series are particularly for this segment, creative freelancers, and even there are tripartite guidelines, standards, and advisories even for this particular segment. So I think, well, it's we soldier on, we develop, and not just VICPA. In fact, we also have the NICA, which is National Instructors and Coaches Associations, and we've seen them make been very pivotal in being the voice for some of these coaches and instructors. They could be teaching bowling, for example, or music or dance, and particularly during the pandemic, it was a tough time for them because everyone is locked into their homes, can't come out and make use of some of these. So they had to reinvent, innovate, and the association actually, NICA, had very close negotiations with various buyers of their services. For example, like Ministry of Education. Many of the music conductors, trainers, coaches were actually servicing the schools, and including community centers, community clubs, and therefore NICA served as a voice for them, and we as a result of that, advocacy could be able to better represent them as a collective whole. and shape some policies and some better protection so that they don't go high and dry. And we even come up with an income relief scheme for them, particularly for this segment, what we call the own account workers or freelancers. And I'm glad, I was involved in it as well. For that entire 1 year, we were dishing out a lot of financial help through the Self-Employed Income Relief Scheme, SERS for short. So that's one example of how we are doing more for this freelance segment beyond just the platform workers.
Thanks, Patrick. Just tagging on to this, just following on this is a rather popular question as well. So they mentioned that in some countries like UK or Netherlands, right-here workers are treated as workers under employment law and not independent contractors. So I think you mentioned before that there's, employees, and then there's independent contractors, and now with the new act, you have an in-between, which is the platform workers. So are there any similar future plans for Singapore to go more towards the employee position, or are we happy with this hybrid at the moment?
At the moment, it is hybrid. Actually, if you look at some jurisdictions, for example, in UK, there's also this kind of hybrid arrangement. And I think this is what is serving us at this moment. There was a very long discussions on this, on whether we should classify them as employees or make it very binary, But we decided to go on this middle path and hybrid so that we can better look after the very fundamental rights. And that's where our intent was. And like I said, it's still early times. We just passed the law and effective this year. I think we will definitely do a watching brief and closely look at this and some of the things that come out and emanate from it. In fact, we are still in the process of forming platform work associations. Getting platform operators to be on board the platform work associations. I think that's a work in progress, and we hope more of the platforms, in fact, as many of them as possible, to be on being with us, so that we can better look after the interest and welfare of platform workers.
Thanks. Celeste, maybe this question is a bit for you. It's about the application of the Act to cross-border. Okay, I think the audience member, perhaps, they're thinking in the future, maybe there might be cross-border ride-hailing, included as part of the apps. So would workers take part of that, would they also be protected by this? So example, in Malaysia's, let's say they launch their own maybe cross-border hailing app and locals here in Singapore sign up for that, would they be covered, or is it triggered by that the platform is in Singapore?
Oh, yeah, that's right. So as I say, as with most legislation, generally it does not have an extraterritorial kind of impact. I mean, there are legislations that have that impact where it's specifically provided in the Act. But from my reading of the Act, and Patrick can correct me if I'm wrong, I think it is intended to be for platform operators operating in Singapore and platform workers working in Singapore.
Yeah.
So there are certain jurisdictional limits, from that.
I mean, just like any, just like a typical employment situation, the starting principle is that where you deliver your services, particularly in Singapore, and usually Employment Act and employment-related legislation tend to be where the person, him or her, is physically and geographically situated, and of course delivering those services. So that's the fundamental rules, this employment space. Yeah.
Thanks. Another question we have from the audience is that, of course, besides protecting platform workers, is there some thought around would the Act maybe in the future make platform operators vicariously responsible for the action of platform workers? So if there's anything that happens that causes damage or injury, besides going after the platform worker itself, you're able to go after the platform operator?
Yeah, like I said, it all depends on how we develop this space. I think we're doing this through insurance now, and I'm very, very sure some of our platform operators have started buying insurance to cover themselves and to protect themselves from especially some very, very large claims and things that are a bit beyond their control. But currently, of course, the concept of vicarious liability is always in the employment relationship. Therefore, not yet, but we started with these 3 areas, which I mentioned. But we'll see how it develops. But definitely it's not an end game or closed door to us developing further, because even as close by as our neighbors, they are looking at the Gig Workers Act and looking at areas. And I would say it's quite a bold move to cover even other spaces, and in a more far and wider way. Therefore, it's something we are paying a close watch to, and we hope that some of the cases will develop, and as we resolve some of the grievances, some of the real life cases and the use cases, we can then decide how we can move forward, whether to expand, to deepen, or even have a greater ambit of the act itself.
Thanks, Patrick. So I think one question from an audience member is around, I think, fatigue management guidelines. Because unlike, I suppose, a regular employee, which has a 9 to 6 job, gig workers can pretty much work 24/7 if they're so inclined to. So their question is, if the platform operator does not have any fatigue management guidelines and they keep pushing jobs to me and I suffer from, let's say, heat or physical exhaustion while working, I think first, can they claim compensation against the platform? And second is, does the association get involved in such situations?
Yes, I will say yes to both. If that's why, if any of you are members of our associations can actually represent you if you have any grievance on the ground, overwork, excessively, etc. But earlier on, also I alluded to the fact that the WSH Act, the Workplace Safety and Health Act, has now further expanded to cover platform operators. So there's, in a way, a duty and responsibility for platform operators to ensure there's fatigue management processes, and well, if you are really overworked and forced to push to the edge of a cliff, please call MOM. Or if you are a member, call one of the associations of which you are a member too.
Yeah. Maybe just to supplement that, since, workplace health and safety seems to be quite important consideration, right? Is that, as Patrick mentioned, the WSHA has been amended to include duties of platform operators to ensure the safety and health of platform workers. Very similar to how employers got to, ensure reasonable measures to protect the health and safety of employees, right? And so maybe just for, as illustration, with respect to platform workers, these would include things like ensuring that platform workers are properly trained, and that they are provided guidance on checking their vehicle and other equipment, and that they have the right licenses. And platform operators must also, with these enhanced kind of provisions, identify and mitigate safety hazards. Platform operators must also establish emergency response plans. And then, as Patrick mentioned, they should, establish fatigue management measures to help reduce risk, from fatigue and heat. Yep. So these are some of the measures that come about as a result of the enhancement to the Workplace Safety and Health Act.
Thanks. And I believe this can be found in the USU guide, correct?
Yes,
Patrick?
yes. I need to flash this up again. Yeah. Titled A Guide to the Platform Workers Act. Nice copy here. Sorry, not available in hard copies. You have to download it or to the link and get a PDF copy. And again, an appeal and call out to everyone. Not just follow my socials, but more importantly, to share this far and wide with all your friends and fraternity in the platform workspace.
Thank you. So that brings an end to our Q&A session. So I think first I'd like to ask the panelists to give us maybe one key takeaway before I'll go on to share more about resources that you can avail yourself of on this topic. So key takeaway is maybe start with Celeste first.
I think one key takeaway, is that I would encourage, the audience to know your rights and what, protection you can get. So I think knowing the law is always the first step to understanding how best to manage, what you want to do, and to manage, any risks, and to better protect yourselves as well. So I think that's one thing. And obviously the handy guide is a good place to start.
And for me, all I can say is you never walk alone. Yeah, so if you're a platform worker, not to worry. The platform work associations, if you're a member of, will walk that journey with you. As I shared earlier now, with representation that's available to you if you are a member of a platform work association. Likewise, now with additional measures and protection, what I call the three-piece meal of not just union representation, but of course coverage under the Work Injury Compensation Act, and finally CPF contributions, which will help you in your retirement adequacy and acquiring your next home. So all these things are now available to you, and as what Celeste and we collectively urge all of you, equip yourself a copy of this brand new pocket series, actually dedicated to each and every one of you platform workers out there.
Thank you, Patrick. And this is a great segue into an introduction into NTUC and how you can find out more information. All right, as shown on the screen, as an NTUC member, you enjoy even more benefits. Unlock exclusive savings and perks that help reduce your daily expenses, from groceries to health and wellness products, plus injury protection while on the job. NTUC membership gives you both savings and peace of mind. Now that we've seen how NTUC membership can benefit platform workers, here's how you can sign up and be part of the community. As you can see on the screen, there is that handy nifty QR code. By joining NTUC, you'll get access to stronger representation, financial support, CPF guidance, and exclusive membership benefits. Simply scan the QR code and sign up today. And I guess, to help facilitate that as well, there's also an exclusive promotion. If you pay for 3 months, you receive $20 fair price e-vouchers when you sign up. So join NTUC and be part of a community that's there to really support and protect you, if you're a platform worker, etc. I guess, Patrick, if you're not a platform worker, do you also get the code as well?
Yes, you can also sign up. I said that we welcome all. And whether you're in employment relationship or not, beyond platform workers, some of you may be not platform workers, but intending to go into it or currently have a job and, watching this and tuning into this because you have a relative, friend, family member, or, who's in this space. Likewise, if you are working anywhere, we welcome every one of you, whether you're the worker on the ground or even the HR person or the boss. Everyone can be a NTUC union member so that we can help you in what we call wages, welfare, and work prospects.
One question I have, out of curiosity, must you be currently a platform worker or be employed in order to sign up to be an NTUC member?
Yes.
What if you're unemployed?
Good question, Serene. Yes. Usually, as I shared earlier, there's a requirement for you to be in an employment relationship. However, we do make arrangements. For example, like workers who are retrenched.
Yep.
They may be my member. I mean, in fact, sadly, I've been helping many retrenched workers. So the union does go the extra mile to allow them to continue to stay as union members, to tide them over until the next job. Because in fact, when they are out of job, that's the time where they really need union membership to tap on some of the skills and youth training support and grants and a lot of the hardship and release schemes. So therefore, if you are employed and happen to lose your job, you will still be able to cover as long as you continue to pay your membership dues and you can tap on some of the schemes. And schemes are not just to benefit yourselves, but also your family members. For example, like some of the UK fundraising we've been doing to help our families stretch a dollar. At the same time, also to help our families' children in school through grants, to bursaries, scholarships, etc. So these are but measures which we continue to appeal to help all of you. However, I know, since it's a timely question, if you are unemployed and you happen to be unemployed or involuntarily unemployed, I wanted to help our tripartite partners sell this scheme as well. There's now the Job Seeker Support Scheme. So if you happen to be involuntarily unemployed in the last, you've been sort of either made redundant or for some reason terminated from your previous work within the last 12 months, you can actually apply for the Job Seeker Support Scheme. Just Google it, Job Seeker Support Scheme, and you can get up to 6 months, or should I say $6,000 worth of assistance for a period of 6 months. However, you need to fulfill some condition requirements such as partaking in some activities to help in your employment and employability, including training programs and job fairs and job counseling. So this is just an additional sharing, because I think some of you because I know personally, I mean, I've taken ride-hailing, I've tapped on ride-hailing services before. Some of them may be doing it as a while in the course of unemployment. They may have, I know particularly one, I just took one of the ride-hailing services not too long ago. And he was sharing with me, he just got laid off in a particular company which I'm quite familiar with. And he was doing this just to tide over the period and sort of like so that he can continue to support his family and his 2 children. So definitely, I know some of you who may be unaware. There's actually this help scheme called the Job Seeker Support Scheme. So do tap on it. It just started in April this year. So it's really fresh from the oven, something which it took a while for myself and the labour movement to lobby for. So make full use of the scheme to help you land your next job.
Thank you, Patrick. So on this point, I think we have the next slide. So I think, this amazing free resources that's available to everyone, this webinar as well as a booklet. So I guess we just want to express our appreciation to Pro Bono SG and also just make a mention that if you would like to, you can make a contribution to Pro Bono SG to support the Trailblazers Fund to set pace for their crucial access to justice work with vulnerable and disadvantaged communities facing legal challenges. Your commitment towards Pro Bono SG's mission to inspire others to follow the generous lead to sustain their critical work in providing legal awareness, guidance, and representation for those who cannot afford lawyers, including lower-income individuals and under-resourced nonprofits. The funds raised from this campaign will go to Pro Bono SG's general funds. So I think there's a QR code that you can use if you feel like donating. And lastly, if you are facing any issues and if you are an NTUC member and keen to register for the legal clinic session that Patrick had earlier mentioned, you may write to lawworks@ntuc.org.sg. If you are a non-NTUC member, do consider to register as an NTUC member, or you can approach Pro Bono SG at help@probono.sg. So that brings us to the end of our webinar, and a survey form will pop up on your screen for your completion. We appreciate your comments and feedback so that we can improve future webinars. With that, on behalf of Pro Bono SG and NTUC, we would like to thank all of you for joining us today. Have a good week ahead.